evening and welcome to the program Political Matters. My name is Susan Eze. Nigeria may be done with the general elections, but can we say done and dusted, considering the level of dust raised by the process? This dust is yet to settle, with many election petitions still going on in the courts, in the election petition tribunals across the country, including the FCT, where the petition tribunal is looking into the presidential election. The question is, must every election cycle end up in the law courts? These and many other questions arising from this situation is what we will be looking into in today's edition of the program Political Matters. With me in the studio to dissect this issue is a learned gentleman. He is a legal practitioner. I'm talking about no other person than Barrister Tom Ogwo. Barrister Ogwo, you're welcome to the program.
Thank you for inviting me.
All right. Now, yes, we know it is a constitutional responsibility of the judiciary to determine the outcome of elections when they arise. But then, can we say there's an overkill? Every election cycle ends up in the courts for the judiciary to decide. Is this a good process?
Well, it is a yes and no answer. Yes, because it is a constitutional right of any citizen of Nigeria by Section 6, sub 6 of 1999 Constitution, that when you have any infringement of your right, you can seek redress in court. You can ventilate your anger in court. To that extent is a yes, because someone who is going to court has something to ventilate, as being is not happy with a certain situation. So he has his right to go to court to seek redress. Then no, on the other side, is that not all cases ought to end up in courts. There are so many cases we call frivolous cases that ordinarily are not supposed to be in courts. Some of them are academic. When we say academic, it is cases that are not live, cases that cannot bring anything to the table. But people will decide to either as a kind of distraction or to unsettle the other person and go to court. To that extent, not all cases will be in court. So that's why it's a yes or no answer.
Okay, you mentioned academic, and that brings a question to my mind. I know that the electoral process stipulates time frame for every activity building up to the election proper. Pre-election matters. For instance, somebody who is competing in an election, somebody who is contesting in an election, there is a period for screening, there's a period for primaries. Now, how come that even when the elections are over, you still see issues concerning the person's credentials, his academic qualifications, still appearing as a matter to be contested, even when the election is over? Is it out of order?
Not necessarily out of order. In terms of qualification, it's not purely a pre-election matter.
Okay.
Yes, sir. It's not, because it's only when you have information about someone's qualification that you can challenge it.
Okay.
It's only when you have the information about it, when it is at your disposal, that you can challenge it. When we're talking about pre-election matters, you're talking about time to give notice to INEC for primaries, time to do primaries, and time for one to purchase forms and all that. These are pre-election matters. So if you have issues with it, you can challenge it. You are challenging the process. But in terms of someone's qualification, it's not purely a pre-election matter. If you have access to someone's qualification in terms of academic qualification and you have issues with it, during pre-election matters, you can challenge it. After election, post-election matters, you can also challenge it.
Okay, it depends on when you discover that fault.
Yes, sir.
Okay. Now, I ask, just like you said, it is constitutional to take your matter to court when you are aggrieved concerning the electoral process. Now, is does this have an effect on our democracy? Does it help our democracy to grow, or is it bringing it down? I mean, is it healthy? That's the question. Is it healthy for our democracy that we remain in court months, even years, after election has been concluded?
It is healthy to the extent that going to court with life issues strengthens our democracy.
Okay.
However, our procedure of keeping it very long time in court, wherein someone's tenure is ought to end in 4 years, you're spending 3 years in court, that one is our procedural error. But in terms of going to court, it is good for judiciary. I'll give instance. When P2B was the governor of Anambra State, Ngige spent 3 years before P2B won in court. And P2B was sworn in around, I can't remember the year, was sworn in for the first tenure. He spent only 1 year in office, and another election was conducted in Anambra State, wherein Anduba was declared the winner, and P2B was kicked out of office. He went to court to determine tenure of a governor.
Okay.
That court he went helped Nigeria to determine when a tenure of a governor or a president is deemed to have started. In that judgment, he said it is at the point you take oath of office. So your own 4 years will begin to commence from the day you take oath of office. So you find out that landmine judgment helped our democracy to streamline the tenure of office of a governor or the president of the country. So today you have staggered election, courtesy to that court that P2B went. If he didn't go to court, if he had chickened out, today somebody would just be in the office and spend the whole of 4 years, and the court will declare that person the winner. It will now amount to academic.
Okay.
Because the person has spent your 4 years in the office. But with what happened, it means that if that person has not been sworn in, or if he's sworn in and spent only 2 years, he still have other 2 years to complete his tenure. That's why we have staggered election in Anambra State, in Kogi State, in Osun State, and some other states in Nigeria today. So going to court helps. The same thing to other landmine judgment you have in our political matters that define our democracy. So going to court in its entirety is not wrong. However, the problem we have is the time, the duration of the cases. That's the problem we have. And why I say that is that we can do better. We can do better. Election matters has time frame within which to commence and end it. But we can readjust our election timetable in such a manner that we can start a case, conclude it even up to Supreme Court before the tenure of the purported election or the winner of that election kicks off.
Okay.
Like I think it is what is happening in Kenya, for instance. So what you are now saying is that INEC, taking the last general election, INEC has the Electoral Act, which they were instrumental to the framing of those laws, to the innovation, landmine innovations in that Electoral Act. One of which is electronic transmission of results, that a result will be electronically transmitted. But what did we see that is being ventilated in the tribunal, in the presidential election tribunal? We've seen where the INEC itself is admitting to the fact that they did not transmit some of the results electronically. That is the complete breach of their own laws. And it was what made INEC to bring beavers was the failure of card reader, wherein we have what is called incident form in 2015. Where the card reader fails, you should use incident form. And people discovered a lot of flaws, a lot of rigging, manipulations in that incident forms, and now brought in the issue of beavers. That wherever the beavers does not work, election that place should be cancelled for that day. So we shouldn't even generate any results where beavers machines were not used. But what did we see? So that's the problem. So it puts a question mark in the credibility of the INEC. And when you look at it, beam another searchlight in it, you find out that it's not all connected with the manner in which the person who is the leader or who is the boss of the commission is appointed. But the question now is, assuming the non-workability of beavers favored another candidate that is not the party in power, would they have gone ahead to continue? This is a question mark. And like I said earlier, that likelihood of bias is what? Bias. Because law does not give room for another means or manual collation of results. There must be a transmission of results. So that is the problem we have. So if we have to do something about it, you should look at the mode of appointment.
Okay. As you look at the mode of appointment of the head of the electoral umpire, some school of thought also believe that there's a flaw in the mode of appointment of judges in the country, and that also is a factor. They also believe that the mode of appointment of judges affects the credibility of the judiciary to deliver unbiased judgments. Do you agree?
I agree with it completely. As a legal practitioner, I'm not at home with the mode of appointment of judges.
Okay.
Judges are supposed to be seen as being above board, though they are human. But in our system, I think there is a deliberate effort to weaken the institutions so that the party in power or the government in power can always use them at their whims and caprices. First, if you go to section 231 of 1999 Constitution, from sub 1 to 5 or so, it stipulates the mode of appointment, the process of appointment of judges. Both the Chief Judge, the CJ, and the Chief Judge of Nigeria, and the Justice of the Supreme Court. You find out that the NJC will recommend, the President will appoint, the Senate will confirm. Okay. NJC will recommend a person for the appointment, for the President to appoint as the Chief Judge of Nigeria, subject to the confirmation by the Senate. Senate is a separate arm of government, is the legislative arm of government. President is another separate arm of government.
The executive.
The executive arm of government. Now we are bringing two arms of government to determine who becomes the head of arm of government.
The judiciary.
The judiciary. So the judiciary is now the whipping child. Now take it to the Senate President. Judiciary has no role to play in the appointment or in the election of a Senate President. It is the President, the senators among themselves that will decide who will become their leader, the Senate President, amongst them, what they call the primus inter pares. Then, in the executive arm of government is determined by election, when we elect our president. But the people that the president will work with, the ministers or the appointment, is the prerogative of the president. So the president solely determines the executive. Judiciary has no hand in it. Why should the executive and legislative arm have a hand in determining who becomes the chief judge of Nigeria. That is wrong. We have NJC. NJC, if you look at the composition of NJC, it's made up of credible people. Made up of credible people that are capable to do those things. So subjecting them to the executive is a way of weakening the institution. Appointment of judges, still go through them too, is a way of weakening those people. Because as human beings, it's difficult for you to look at a man that made you a judge when he appearing before you having a case without having to think twice as to giving judgment against the person. It's rare. You have very few people that will be courageous to do that. And we have seen in our climb where judges that are supposed to be immune from political struggle and all that, where the executive, because of the kind of powers they have, they wield in our constitution, and even order for the arrest, detention of judges without reasonable cause. We have seen in this country where a whole chief judge of Nigeria was removed by just an ex parte order made by another court.
Okay, now, talking about discipline. If a judge or the Chief Justice of the Federation errs and needs to be disciplined, on whom lies the power to discipline or even to remove the Chief Justice of the Federation? Who can discipline him and who can remove him?
Yes, the Chief Judge of Nigeria, NJC, has the power to carry out investigation. If there is any infraction on the Chief Judge of Nigeria, they will carry out the investigation. And if the Chief Judge is found culpable, is liable to allegations leveled against, they will recommend to the President for the removal. It must go through normal process. That's the procedure, which also is what I also fault, because he is bringing the executive into the affairs of the judiciary. If we strengthen the NJC, give them the power, remove any attachment with the executive, because the judiciary has no hand in that of the executive. If the CJN brings any code of conduct, or there is any allegation against him that is proven to be true, the NJC can handle that. But as it stands in our law today, NJC can only make recommendation to the President to carry out that. Like the case I mentioned, the case of Onohe. When he was removed, he didn't go through the process of NJC. What the federal government did was to file an ex parte application to Code of Conduct Tribunal. And it was granted. As questionable as it was granted. Many people were not at home with it because it is a ridicule to judiciary. And the man was removed in that manner. I don't think that anybody can contemplate removing the President of Nigeria by going to court to file an ex parte application, no matter how grievous the allegation is. I don't think anybody can do that. So, and the three arms of government ought to be equal. One ought not to be more powerful than the others. But in Nigerian setting, our constitution, it was framed in such a manner that the whole power centers on the executive. So that's the issue.
All right. You have extracted in depth some of the issues surrounding the judiciary that seems to make their hands tied. But then, by and large, the entire society looks up to the judiciary, to deliver when the need arises. It is said that the judiciary is the last hope of the common man. Now, going by antecedents, Nigerians are gradually losing faith in the ability of the judiciary to deliver unbiased judgment. How can they rekindle the people's hope and trust?
Well, no matter how bad it is, judiciary is still the last hope of a common man.
Okay.
We cannot say it is entirely bad in Nigeria. we still have landmine judgments in so many areas. We have had a situation in 2019. I'm talking of a Zamfara case, where judiciary came to the rescue of our system. In that case, APC won the election without conducting valid primaries, just because of interest in that state. And to the surprise of many people, that judiciary will be bold to make such a statement. And they made a statement that because you don't have valid primaries, all the elections won by APC in Zamfara state is taken away, given to the party that came second, irrespective of the fact that APC was the party in power in Zamfara state and also on the federal. So there is still hope. There are some minor things that are happening which also affect the credibility of our judicial system. For instance, in so many states where election tribunal is going on, it is the state government that provide the logistics. The hotels where they stay, the judges who come for the election petition are staying is sponsored by the state. The vehicles which they use to convey the judges from where they stay to court, back and all that is by the state government. And I don't think there's any election tribunal where a state government is not a party. Because when the party in power is in court and the state party in power is providing the logistics for the judges, of course the other party will not be comfortable, will not be at home with it. These are some of the reasons that will lead to some people applying that the tribunal be relocated to Abuja, just for fairness. So what we're saying is that Nigeria should have hope for our judiciary. It is not completely bad. We have had good cases in the past, especially this, our presidential tribunal. We should have hope with them.
Okay, I was coming to that before we wrap up. Give us your own view, your own impression, that presidential tribunal that is going on, the issue of whether or not the public should follow the proceedings. Your own impression. Is there anything wrong in Nigerians following the proceedings? Is there any legal implication of allowing the media to carry the proceedings, for all to see what's going on? What's your own view about that matter?
You see, at this age and time, it's not even supposed to be something to contest about. It should be an issue that at the outset, they will aid the proceeding. It has nothing to affect the tribunal going on. It has nothing to affect it. You aid it if you don't have anything to hide. Most of us follow the proceedings in South Africa when their own happened. We follow it. So I think the proper thing to do to even redeem the image of this country is for them to air it. Let it be televised. Let every Nigerian has the opportunity to watch it. Many people want to follow the proceedings. All of us cannot be in Abuja. So many lawyers will want to follow the proceedings. Exactly. All of them, courtroom is not big enough to accommodate all of us. So there's nothing wrong in making it to be on air.
Thank you very much. I'm afraid that's the much we can take on this evening's edition of the program Political Matters. My guest has been Barrister Tom Ogwo. Barrister Ogwo, we thank you for being a part of us this evening.
Thank you. Thank you, the viewers.
All right. Thank you for watching. See us again next week, same time, same station. Good evening.